Welcome, everyone, and thank you for joining us for Professionalism Tips for Practicing Law in the Digital Age. My name is Jaclyn Behar, and I'll be moderating our discussion this afternoon. I've been a litigator in Florida for the past 16 years, and like many of you, I've watched technology fundamentally reshape how we interact with clients, the courts, and each other. Today's program is designed to help you navigate this digital legal landscape with confidence and professionalism. We'll be focusing on 4 key areas where technology intersects with ethical obligations and day-to-day practices: virtual appearances, electronic communication, social media, and electronic data management. In each segment, we'll talk through common challenges and practical strategies, drawing on our panelists' diverse perspectives as jurists, practicing attorneys, and educators. Whether you're logging on to a hearing from your home office or drafting an email to opposing counsel, we want to equip you with the tools to maintain professionalism, protect your clients, and comply with your ethical obligations. We have a great group of panelists here today. Could you each please introduce yourselves and tell our audience a little bit about you and what you do? Amy, can you kick us off?
Good afternoon, everyone. My name is Amy Bandow. I serve as the Director of Campus Administration for Cooley Law School's Tampa Bay campus. I've been with Cooley for approximately 13 years, and over that time period, I've held a variety of faculty and staff positions within the school, and now I work as an administrator.
My name is Arti G Harani. I'm a shareholder at Meenakshi A Hirani, PA. I am the Orange County Bar President for the next 36 hours and the incoming President, so President-elect of the Florida Bar YLD. And I practice in probate, estate planning, and international and domestic tax sheltering.
Good afternoon, everybody. I'm Judge Christopher Wigand. I am a circuit court judge in Broward County assigned to the family division.
Good afternoon. I'm Shari Africk-Olefson. I am a civil circuit court judge in the 17th Judicial Circuit. I've served in pretty much every division except for criminal. Before that, I practiced business and real estate law, and I ran a think tank for 10 years in Florida, New York, and Washington, D.C., and have several books published on those related topics. But I'm here because I'm a lifelong learner, and I'm excited about the prospect of digital, but also the long and short-term impacts on all of us, on our profession, on the justice system, and even on our brains. I happen to be a student of neuropsych and just love that topic. So I'm interested in seeing what else our other panel members have to say as well.
Thank you all so much, and thank you for being here today. Our first area of focus is virtual appearances. Over the past few years, remote proceedings have gone from being a novelty to a standard part of legal practice. To some extent, we are all conducting hearings, mediations, depositions, and client meetings over Zoom or other video platforms. Initially, there were a lot of bumps in the road, and stories of Zoom mishaps were a popular topic of office conversation. I think we all remember the lawyer who said he was not a cat. I've attended many programs regarding how to use virtual conferencing effectively and professionally. So much so, in fact, that I wasn't sure if we should cover virtual appearances today. Unfortunately, after speaking with our judges, it's clear that we all need some reminders. The first thing for everyone to remember is that we should approach virtual appearances with the same level of preparation and polish you would bring to a physical courtroom or conference room. That means checking your technology ahead of time, dressing for professionally, and minimizing distractions. It also means being mindful of how you present yourself on camera and on the record. With that said, for our judges on the panel, what are some of the most avoidable mistakes you see lawyers make in virtual court appearances?
Chris, you want to take this first, or you want me to?
You can go ahead.
So big picture, and I think something that's important for all of us because it really goes to sort of the fundamental reason that we're lawyers, right? And that we didn't become podiatrists and we're not loading luggage for Delta Airlines, right? Is that we believe in the justice system. And one of the biggest problems I see is that people have grown very accustomed to using FaceTime as a casual tool and Zoom as a casual tool. As officers of the court, I think it's important for all of us to preserve the integrity of the court and the courtroom and remind our clients and ourselves that a hearing or a trial is not a kitchen table conversation Without that, the entire system really falls apart. So the best rule of thumb is if you wouldn't do it in an actual courtroom, it's not appropriate to do in a Zoom courtroom. So that goes to covering multiple hearings at the same time. It's pretty surprising to me every time a lawyer says, "Oh, I'm sorry, I didn't hear you. I'm covering 3 different hearings at the same time." I don't want to know that. If I know that, that's a bad thing, right? You wouldn't be in 3 different, running back and forth in real life to 3 different courtrooms. And presumably you're being paid by each of those clients. You should be fully present. The same thing goes to participating from a car. I've had lawyers participate from airports. I've had litigants participate from their bedroom. And if they can't help it, if there's a financial constraint or something like that, that's fine if they let us know in advance. But generally as a practice, same thing with dressing inappropriately or not turning your camera on, right? You wouldn't walk into a courtroom with a paper bag over your head. A big issue for witnesses, especially during trials, is forgetting that the judge can see and hear you. Even when our camera and microphone is off, we still see everything that's going on in Zoom. Or forgetting to actually leave the Zoom courtroom. We had a trial once where a witness was in the waiting room, and you can be let in from the waiting room at any point in time. And I guess he had been waiting for an hour or two. And when I clicked to let him in the waiting room, he was in the restroom and had rested his telephone on the sink and turned around, and we all got a full frontal. So I think it's really important to remember that you're in a courtroom. Appropriate device use is important too. We had a trial last week with a very sophisticated real estate owner who participated in the whole trial as a plaintiff on his cell phone, and it was very disruptive. I would suggest that lawyers have clients come to their offices and participate from there if you want to be on Zoom. The other biggie, which I think is just a convenience factor, is remember that if your exhibits are not actually entered into evidence, then they don't exist. For anyone who practiced real estate law like I did, if it's not in the public record, it didn't happen. So if you're going to have a Zoom trial or a Zoom hearing, make sure you get the clerk hard copies of your exhibits ahead of time so that they can enter those. It's surprising the number of people who forget to do that, or it's just not even on their radar screen. I think those are sort of the top issues that we're still seeing. Like you said, a lot of this has resolved.
Yeah, and just following up on what Judge Olefson said, the most avoidable things that I can see are technology use. People will come in, they don't turn their cameras on, they don't know how to unmute themselves. Little things like that hold up hearings, especially in the morning when you're having a uniform motion calendar where you have a bunch of people that are having 5-minute hearings at one time. When you call parties and they have to take time to turn everything on, it delays the process for everybody. And then the other thing is making sure that they're dressed professionally and in a professional setting. People showing up on cars occurs every day. They're trying to drive while they're doing a Zoom call. Not only is it dangerous, it's unprofessional. Lawyers and clients coming in dressed inappropriately. If you wouldn't wear it to court, you shouldn't wear it on the Zoom hearing. So I think those are the biggest avoidable mistakes.
Oh, I forgot one other thing that we talked about. Can I add one other thing, Jaclyn? And that is putting your name in, because as I mentioned to the panel when we were talking before, we have recently had incidences of someone infiltrating the court systems on Zoom. I have no idea why, but all of a sudden we'll be in motion calendar with 50 people on the screen, and this, like a little porn flick, will start playing. They enter the courtroom as a blank screen with their camera off, and then it starts this porn thing. I've had it happen so many times, I'm not surprised anymore, but I still get lawyers gasping. But if you enter your name in the screen properly, then if you're in the waiting room, we can see who you are and we know you're appropriate. Otherwise, a lot of the time we have to wait, or I have to have the clerk watch, because there's a lot of stuff going on during motion calendar. You're trying to attend to the hearings and let people in from the waiting room and see who's who. So I think entering your name properly and letting your clients know to do the same thing is really important, so we know who is who.
That's a great tip. And I was actually going to ask about that, because I remember you telling us in our prep call, and I was shocked that was an issue as well. And obviously it's important for the court to know who everyone is once you start presenting, but I hadn't realized the importance of having your name listed even when you're signing in before the hearing actually starts. So that's a great tip for everyone. Arti, outside of court appearances, do you think professional expectations have evolved for virtual meetings such as client conferences, mediations, or depositions?
Absolutely. So our culture right now is a lot more casual, and that is fabulous. But your clients are still paying for an attorney. And so I know a lot of people have allowed their clients to access them via cell phone. This is going to sound really simple and almost silly, but when you're typing the word you, don't just type in the letter U. They are paying a lot of money to request someone who obviously has a lot of education. And I think we can all spell out words or isn't it? Things that you wouldn't usually say are now being acceptable. I am a young lawyer, but I do understand the value of being perceived as it. The Florida Bar considers us to be attorneys 24/7. And so when we're with our clients, we should act and behave like that. I actually went to meet another attorney. We were talking about a case and they were in shorts and they answered one of the calls in the shower and I could hear the shower and they told me to wait. And we weren't on a Zoom where they could hear it. We were just on the telephone. But we also had another client coming in and they were paying us a lot of money to talk about tax sheltering and irrevocable trusts. And they didn't really want to give us that much money at the end of the day when they found out that one of the other attorneys, not from our firm, was in the shower. And so it's things like that where even though we're now accessible a lot more, you should still keep the veil up that we are professional and make sure that we're acting appropriately. We're talking the appropriate ways. Even when you email, like make sure that it still sounds like you're an attorney and not just their friend.
Those are great practical tips. Thank you so much. And I know we have an additional panelist that is joining us here today that has been stuck in the attendee portion of our webinar. And I know Katie from the Florida Bar is working on getting him over. So once he is, I have some follow-up questions for Paul as well. But it looks like it hasn't happened yet. So, as we all see, it doesn't matter how prepared everyone is. Sometimes these mishaps still happen. And there's really nothing that we can do about it other than try our best to prevent it. With that said, I'm going to try to dive into our next topic, which is electronic communications, emails, text messages, and other forms of digital messaging. These are the lifeblood of modern legal practice, but they're also one of the easiest places to make mistakes that have real consequences, whether it's a reply all slip up that breaches confidentiality or a hastily written email that escalates a dispute. Lawyers have to be extremely careful about how they use these tools. So let's talk about some best practices regarding composing and reviewing emails and avoiding tone and content missteps that can hurt your reputation or even violate ethical rules. Amy, as a legal educator, what would you like law students and young lawyers to know about electronic communications?
I'd like them to know that when they enter law school and subsequently enter the practice of law, they're beginning a new and exciting chapter in their lives. But with that also comes a new chapter in terms of new expectations and a new professional environment. And so there are various formalities and best practices that go along with those communications in that type of professional setting. And often students transition into law school soon after finishing their undergraduate education. So they may not have had an opportunity to work in a professional environment where they've had exposure to those types of communications. So then when they transition into law school, although they may be very tech savvy, which is wonderful, sometimes those informal communications that they have in their personal lives and habits that go along with that related to text messaging end up carrying over into professional communications that they have with their law professors or supervising attorneys. And then, of course, the professors and supervising attorneys notice when students are engaging in really informal communications and not following some of the best practices and common formalities that we have in our communications in a professional setting.
That's really great to hear. So is it your preference that when students communicate with the administration or with professors that they treat that communication as a formal letter?
Yeah, I think that's an excellent tip in following the same formalities that you would have in a letter. So including a subject line in your email, including a greeting such as good morning, using a person's title if they have a formal position, including a closing with your name, and avoiding those abbreviations and emojis and casual talk that you might have in a text message and not carrying that over into an email communication in a professional setting.
That's great to know. Judge Wigand and Judge Olefson, what about the way that attorneys communicate electronically with the court? Have you encountered problems there? And if so, what can we do better?
So the biggest thing that I see is communication with our judicial assistants. All the communication goes through them. And the biggest problem that I see is a lot of lawyers will inadvertently include back chains of all of their email communication back and forth. So, for instance, if they're talking about scheduling a hearing, they will include all of the emails back and forth between the two attorneys before they reach out to the judicial assistant, which usually contain inappropriate, sometimes privileged communications. Usually it's just a lot of bantering back and forth that unnecessarily clogs up our system on our end, is more stuff that the judicial assistant has to go through. So the big thing that I think that practitioners can do is when you reach out to the court, you should have already had all your communications with opposing counsel and know what it is that you're asking the court for and be on an agreement and send one email with that request as opposed to the back and forth. The other thing is that unfortunately will happen is that they will include us in that chain moving forward. So even after they reach out to the court about one specific issue, we're now getting every single response that follows up on that email. So you always have to be careful of who's on that email chain, what you're saying, and whether or not it's appropriate for the court to hear. The other big thing that concerns me is that you will have, because it's so easy to reach out to the court through email, is that you have the tendency to have people reach out and not include the other party. And so you always have to be careful that you're not having ex parte communications. And those types of things can lead to problem. I mean, with the judge, maybe having to recuse themselves depending on what's said. So that's something that they always need to be careful of. And I don't think that attorneys do it on purpose. I think it's just in today's day and age, we're doing things so quickly that we're not taking the time to be careful when we're including the court in such conversations. Shari, do you see anything different?
Well, let me first say that 99.9% of the emails that we get in chambers are 100% appropriate and hugely polite and very, very, very professional. So, it's kind of like our division procedures. You have to speak to the lowest common denominator, unfortunately. And so that's who my comments are really addressed to. 99% of the lawyers would listen to these comments and think, I would never do that. So, and I understand that. And I see that every day. I think it's important to put yourself in the JA's shoes. I don't think there's a harder job than being a judicial assistant. They are so busy. Just super, super, super busy. I mean, we have over 1,000 cases and they get a zillion emails all the time. A lot of the orders, if they're disputed, have to go through the JA, scheduling, those kinds of things. So less is more. When I see a page-long email to my judicial assistant, who is fabulous, it just makes me cringe because he doesn't have time to be reading page-long emails. And if it has to be a page-long, it's probably a motion. It's probably not an email, right? So mostly his job is scheduling. I think keeping it short is important. I join what Chris said in terms of not including him in the bickering. I think sometimes people do that on purpose to they want to show us how bad the other side is, and it doesn't do that. It just makes me cringe for both parties' spouses because I can't imagine having to live with that. So it's not a good idea to copy chambers on anything like that. The other biggie is that, for those of you who have managed people, that it's wonderful to work with people, but managing people can be the most challenging part of a job. So I'm going to say that one of the best things about being a judge is you really don't have to manage employees. You have one employee who's your JA, but you're very protective of your JA. And there's a lot of concern about not having your JA overstep what they're allowed to do. A lot of judges get in trouble because we're responsible for everything they do. So be careful not to put the JA in a position of having to do or say something that's not really their job and not appropriate. I have seen lawyers ask the same question multiple times in different ways because they want to get a certain response from the JA, and it's just not the JA's job or responsibility. Scheduling, forwarding emails to the judge, those kinds of things are the JA's responsibility. No legal questions, no detailed questions, no spats, anything like that. Again, if it looks like what you're putting in your email is actually some sort of a motion or should be a motion, then call it a motion and file it and set it like a motion. Don't send it as an email to the JA.
Those are great practical tips. I see Paul has joined us. Paul, thank you so much for being here. And I'm sorry for the mishap with your invitation link.
Hallelujah. I'm just glad to be with you all. I have been listening attentively, also trying to be a lifelong learner. I'm Paul Schwepp. I'm a practicing attorney at Coffey Burlington, where I've been a partner for about 20 years now. Was also on the board of bar examiners for 10 years and am on the student education and admissions committee for the bar. So again, apologize for the technical issue, but it illustrates the point. I have been sitting watching you all since about 11:55, just unable to talk. So that's sometimes that's not a bad place to be.
Well, thank you so much for being here. And since you're here, the next question's for you. Paul, do you have any horror stories about BCC or reply all gone wrong? And what ethical obligations arise if we are on the receiving end of an electronic communication that clearly was not intended for us?
Yeah, thank you, Jaclyn. I think it's an important question because it's not an infrequent occurrence. I mean, to me, the most dangerous key on your keyboard is the reply all key. I have been both on the receiving end and on the sending end of an email that wasn't intended to be sent to everybody that got it. And there is the rule 4-4B says if you receive an email that you know or you reasonably should know wasn't intended for you, you are obliged under the ethical rules to notify the sender immediately that you received a communication that that was not intended for you. So that's an ethical obligation that exists apart from anything else that arises. You have to notify the sender if you receive information that wasn't intended for you, that you perceive wasn't intended for you. There's also the sort of a rule of self-preservation because you are at risk of being disqualified if you happen to receive and then integrate privileged information that wasn't intended for you. And the case that I was thinking about when we spoke about this in advance, Jaclyn, is Atlas versus Greenberg-Traurig. That's a third DCA decision, 997 Southern 2nd, 1117, where the law firm was disqualified because they inadvertently received information that was privileged. And rather than immediately return it, notify the sender that they received it, they read it. So if you happen to get an email and you look at it and pretty quickly you realize, well, I don't think they meant this for me. The first duty, which is you're obliged under the rule to notify opposing counsel that you received it. But then beyond that, best practice would be sequester that. Don't look at it any further. Make sure that none of the other lawyers in your office look at it, that it's sequestered and a wall of separation exists so they can't look at it. If there's going to be fights later about whether there was a waiver because of the production or whether it's actually subject to any privilege, that's a separate discussion. But in terms of like actually reviewing the content of a communication not intended for you, the risk is not worth the rewards.
That's so true. I was involved in a litigation case where there was a large inadvertent production and receiving counsel didn't notify anyone and used the material. And when they were notified of the fact that it was an inadvertent production, they tried to continue using it. And it resulted in about 2 years of litigation over their disqualification, which was affirmed on appeal. And it wasted a ton of time, and that firm ended up not being on the case anymore. So it can definitely be a costly ethical issue if you get it wrong. Arti and Paul, what are your thoughts on using AI to revise and even prepare emails? How should practitioners protect clients' confidential information in this context if they do decide to use it?
So I will say we actually did a panel with this group before, specifically on AI and ChatGPT. And the point of the matter is we can't be afraid of technology, but the same rules still apply. Every few years, there's going to be a new technology, a new source of things that we can use. And it's not going to change the fact that we're still attorneys and we need to keep confidential material confidential. So now it's ChatGPT. In 2 to 3 years, it's going to be something else. And the rules will still stay the same. So when you're using ChatGPT, you just have to understand that everything you put in there is now open to the public and can be used in any other way. So just like you can't go tell someone who's not in your firm to type up a letter for you and use confidential information, you can't do that using this new tool because that's all it is. That being said, if we're all using ChatGPT, make sure it doesn't sound like ChatGPT. I just typed into ChatGPT to create a letter of a thank you for this great panel. And it says, hi, insert name. Thank you for leading today's panel. You brought such insight, energy, and clarity to this 50-minute conversation. Your guidance today helped share a meaningful experience for all of the 36 people who came to the waiting room. And that was just what I typed in. And sometimes people will just send it because it's nice to get something sent. But you just have to make sure it sounds like you. Just do an edit through.
If I can jump on about that, I'm a frequent flyer with ChatGPT. I love the technology. I heard early on in ChatGPT that we will not lose our jobs to AI, but we will lose our jobs to people who use AI. So, I mean, it's just a tool like any other tool that I think can make lawyers more efficient, and clients should benefit from that. But in terms of confidentiality, I just think it's a no-no to ever include any client-specific information in any ChatGPT search. So, because those are large language models, as Arti's pointing out, that stuff gets preserved. You lose control of it. So there's a client confidentiality concern. I use ChatGPT a lot to almost like a thesaurus, but it's better than that, right? You can take an entire paragraph and dump it into ChatGPT and say, give me 10 different ways of saying this. And very often comes up with ideas you hadn't thought of that are good. But you can't do that and include your client data in it because now it's saving client names and information, et cetera. So it's got to be anonymized. But setting that confidentiality concern to the side can really make the practice of law and then the expense to clients more efficient.
So real quick on that same subject, I just taught on the use of AI in the law and the ethical obligations and complications that come along with it. One of the important things that if you're going to use ChatGPT, spend the $20 a month, get the paid version, because you can change the settings and change it to a closed system as opposed to an open system, which does not share the information with anyone, and it lets you go back through and delete old conversations. So if you're going to use it and put in client information, make sure you're doing it in the closed system so that you are not violating any of the ethical rules.
That's great. And we had a question come in. It says, for many new lawyers, especially solos and small firm practitioners, the pressure to be constantly available is intense. How can we help them draw? That's probably a typo. And maintain, so set boundaries. Draw and maintain healthy boundaries while still providing excellent client service.
I can take that one. I am relatively early in my practice, so it's about 11 years that I've been practicing. But to me, being available to my clients is paramount. I want them to want to call me at any hour of the time to make sure that I am safely keeping their estate whole, that all of their tax consequences are taken care of. And I want them to call me when they are most in need. That being said, my boundaries are at certain points of time at night. So if I wouldn't feel comfortable speaking to someone who is married of a different sex at 10 p.m., then I shouldn't be calling my client or picking up a phone call or answering a text message at that point. And then you can always email them and send them a notice saying, I've received it. I will call you during business hours. Like I said earlier, with another counsel who was working with me on a case, they picked up during the shower. Put your phone away during the shower, things like that.
Those are really great tips. And I had a mentor once tell me, because I had asked personally about, what to do when you get an email and it's something emotional or something that really requires a thoughtful response, but you don't have time and you want to make sure that the other side knows you got it, but you need a little time to respond. And her advice to me was tell the client exactly that. Tell them that you want to give their very important questions some thought and that you'll respond as soon as you can, but within the next 12 hours or the next business day or something like that. So because I don't know why that was such novel advice to me. I used to be really torn about, do I respond at all? Do I wait? What do I tell them? And I think just letting someone know that you're going to respond, but you need a little time, and often making it, kind of a selling point that you do want to make sure you put thought into the answer and give them all the information you need.
From the lens of an old lady, I practiced for 30 years, and I can tell you at the beginning of my practice, when I had more mom and pop clients, it was a different sort of gestalt. Towards the end of my practice, when my clients were, major financial institutions and Fortune 50 companies and GSEs and trade associations, those types of clients never in a million years would have expected me to be available 24/7. So I'm just going to say that the more appropriate clients are more appropriate in their behavior. I think it's important to manage expectations. So put those expectations in your engagement letters. Have your auto responses set up for after hours so that they know, and they do hear back from you. It's just an auto response, and they know when they're going to hear back from the real you. And, remember that we don't identify ourselves, I hope, as lawyers first, right? We are Americans. We are parents. We are siblings and children. We're members of our community. We're a lot of other things before we're lawyers. And you need to establish boundaries in the long term. I mean, as a younger person, it's fine. But, when you have children and you have a family, or you have parents you have to take care of, or you have community obligations, or you have obligations as a judge, for those of you who want to end up there, you can't have, and let me just say it, like maybe a little bit of an obsessive compulsive demanding client infringing on your children's well-being and your time with your children and your own mental health and all of those things. It's just not sustainable. So I would urge people to really establish practices for your practice that are consistent with your personal values, and live your life consistent with your personal values. And eventually you'll have clients who have values that are consistent with yours too.
Those are such important points. And to be fair, it's not just clients. Sometimes it's opposing parties, or even expert witnesses that want immediate responses. And I think that's a great segue into one of our next questions, which is, when communicating with opposing counsel or other parties where tensions might be high, how does everyone on our panel strike the balance between being responsive and preserving professionalism? Do you have a personal process for helping you pause before you hit send?
Well, I'll jump in. And by the way, the judge's remarks about how how we define ourselves, and I was lucky early in my career to work with somebody who reminded me, and I think a bit often, that they were a husband first, and they were a father, and they were a brother, and then somewhere along the line below all those things came the fact that they were an attorney. So. But we are all attorneys, and in the context of litigation, it's a binary deal, right? Where there's a winner and there are losers, and folks are competitive, and I get that. And we can, you want lawyers who are passionate about their cases and feel that sense of competition. It's an adversarial process. However, I've thought this a lot over my career, that the relationships you have with opposing counsel, those outlast the relationships you have with clients. Clients come and clients go, but you see the same folks over and over again. I'm in Miami, and even in Miami, it gets to be a small town pretty quickly. So that email that you send or you draft and you're upset about is it's a mistake, and it's not going to wear well. So you get passionate about things. It used to be you would dictate a letter and an assistant would type it out, and time would go by, and that, time has a way of kind of tempering the passion a little bit. Things simmer down. With the problem with the email, as I said earlier, the most dangerous key on the keyboard is reply all. The second most dangerous is send. So just to let things simmer down a little bit. And one thing I'll do, Jaclyn, is I'll reread my emails and start taking out the adverbs and the adjectives and the absolutes. If you're right, you always, or you never, or, that deceitful, or, all of that, just, take out the adverbs, take out the adjectives, take out the absolutes, let it sit for a while before you hit send. And, there is, we're all obliged to take an oath of admission that we swear an oath to be civil in our communication with counsel. So that should sit on top of all our obligations to our clients.
I have something to add on to that. I think that's amazing advice, Paul. I will also print out my emails and have my assistant read it out loud to me because it is difficult to take your voice out of it when you're reading it on your own computer screen. And it's something more seasoned attorneys used to tell me earlier on. And I couldn't understand why they didn't just check my work on the computer screen. They would make me print it out and then they would redline it. And after the red line, they'd give it back to me. And I was like, there's this fabulous device called the iPad. Why can't you just do it on here? And I could do it from anywhere. And they refused. And they actually made me come into their office. And this was right about the time when we were all starting to do virtual things. And they required me to be in their office while they were writing it out. And they said, there's things that you miss when you're on the computer screen. I didn't believe them because I thought I could do it all. But obviously there was still red marks and my paper would come back bloody. And now I see that when I actually put something on the computer screen, it's true. You miss certain things like certain commas, certain periods, right? And that's why you have someone always look over your work. But when I actually print out the irritated email and I hand it to my assistant and she reads it in her very sweet voice, there's definitely things that stick out. And I realize that I actually can't say this. And then I'll have her redline things that she wants me to take out because we all have those irritating clients or irritating co-counsel and they just continue to do stuff and you can't keep the irritation out of your voice if you tried. And it's better to have someone just bloody up your paper.
That's such great advice. And this is actually one of my favorite uses of ChatGPT because I will often tell it what I really want to say and then ask it to help me make it professional or a little bit nicer. And even words that I don't think are confrontational, sometimes ChatGPT will come back and tell me this is too confrontational. So whether it's an assistant reading you out loud to you or AI, there are a lot of tools out there for us to get a little bit of feedback about how we're talking to people, right?
The tone is an interesting topic because a lot of the time when you are responding to someone in a tone, you're not actually really responding to that person. You're responding to some kind of trigger, sometimes from something that happened when you were 3 years old. So it's also sort of an opportunity for a little bit of self-reflection and a reminder in terms of, what's really your end game with this? Because a lot of the time that tone actually gets you further away from where you want to end up for no point at all. You're not accomplishing anything with inappropriate tone. The other thing I think that's really important is I can't even tell you how many times we see emails as being presented as some kind of evidence in a civil case, including not only inappropriate emails or emails that aren't true or with information that's not true, but also those emails or even text messages where you think you're responding to get someone kind of off your back. And, sort of just assuaging them until you can really get to it. Those kind of emails like you were talking about that come, late at night and you just want to reply somehow. We recently had a case that, thank God, it settled, but it ended in a real tragedy for a child. And the attorney had sent the mother repeatedly these text messages in response, thinking she was assuaging the mother, but it turned out she wasn't really dealing with the issue, and it turned out as a big professional liability issue. So I think anytime, no matter how innocuous it sounds, or if it happens to sound inappropriate, maybe just remember that your text message or email can always end up as Exhibit A. And do you really want that to be what you're leading with, in a court or any situation?
Those are such great reminders. And just like emails, social media is our next topic and something that's also more permanent than people sometimes realize. So social media is our third segment and one of the trickiest areas for modern lawyers. Whether you're promoting your practice, engaging in public discourse, or just sharing a life update, social platforms can present serious ethical landmines. Our goal today is to provide some tips to manage your digital persona in a way that's professional, responsible, and compliant with your ethical obligations. Arti, I know you have a robust social media presence. How can lawyers use social media to their benefit, and what procedures do you have in place to ensure you're doing so ethically?
So social media is kind of like ChatGPT to me. Everyone is on it. It's a great tool. It's a great way to connect to everyone. But you have to do so very, very carefully because anything you put on there is absolutely permanent. A few years ago, we even learned that the Snapchats were not just 24 hours, right? Those actually lived on in infamy with the company. So things like that are really important to keep in mind as an attorney, as counsel. I'm actually going to take you to ABA Formal Opinion 502, and it reminds lawyers that online public commentary, including participation or responding, must still comply with Rule 1.6. You can't disclose any confidential client information, even when you're attempting to defend your reputation online. It's just a reminder that, like we said earlier, you're a lawyer 24/7. Just because you're posting online doesn't mean anything. And I'll say, I actually have someone post for me. He's great. Danny Aller, he makes sure that the content is up to date. I always think that there needs to be a degree of separation between anything I do in the outside world, because I want everyone to make sure that it's proper, that I'm being presented in the way I want it to be presented. And so he helps make sure that, and I'll tell you, I work for my mother, right? She goes on every single page that I have put on, and she will go, which like every photo, which helps the algorithm. But there's always oversight on everything I do, which I really appreciate.
That's great. Amy, are law schools working with students to understand the importance of their online persona? And do you feel like law students are sufficiently cognizant of what they put online?
Yes, schools are working with students to understand their online persona, both from the perspective of thoughtfully and proactively building their personal brand, and from the perspective of online social media management. At the school where I work at, we have a professional development program that students participate in, where they reflect on their online presence and then receive tips on how to build their personal brand and their social media presence. But really at the heart of that is just taking time to reflect and think about aspirationally, what do you want your personal brand to be? And being thoughtful and mindful as you're engaging in social media and posting things. Does that reflect what you want your brand to be and how you want people to perceive you? Just taking that time to reflect on that, because it's so quick and easy for people to post things without really taking the time to think about consequences or how those postings may be perceived by future employers or opposing counsel or the Florida bar or any number of people.
That's so great that law student or law schools are helping students with that information and understanding the importance of it early. I know that when I was in law school, Facebook had just started and people were still really figuring out what it meant. And so we've come a long way since then. Judge Wigand and Judge Olefson, I know it's common for judges to have social media profiles, for purposes of elections or their nonprofit work, or even, to promote mediation practices after they leave the bench. And typically they also connect with lawyers that may practice in front of them. Do you have any advice for lawyers that are using social media who may connect with or interact with judges online?
So, Shari, why don't you take this one? Because I'm in a little different perspective here. When I came onto the bench, I shut down all of my social media accounts. I didn't think it was appropriate for me to have anything. There's a lot of security issues when you're on the bench. I didn't want people to be able to locate me and have that aspect of it. But prior to going on the bench, I made a point not to friend any judges. I didn't want to put something on there that would put a judge in an uncomfortable situation. I didn't want to put something on there that if I came in front of a judge, they would be thinking about. So I was always mindful of who my friends were, what I was posting. And even when I did have social media, it was very limited. I did not want to put myself out there. And I know I'm a little bit older. I know it's changed. I came from a practice area. I did plaintiffs, personal injury, and medical malpractice work. So nowadays, that's the main way to get clients in that area. So when I was coming up as a young lawyer, it was more face-to-face interaction. So when social media started coming about, I just always was cautious of it. And I know that's not the norm. So Shari, what's your thoughts on this?
So I had 2 books published starting back in 2008, and I did a lot of things on, CNBC and Fox and all that talking head kind of stuff. So I was on social media pretty actively, and I had websites for my books, and I did develop content for the National Association of Realtors and Consumer Financial Protection Bureau, and our think tank did a lot of communications like that. And I have my doctorate in education, so a lot of it was educational. I took all of that down when I was elected. I'm still on Facebook personally because, frankly, as a 62-year-old, I would not remember anything I do in my life if I didn't have Facebook to look at it and see, oh, yeah, that was, last summer, that's what I did. But I usually don't. I use the privacy features to not have anyone except for really family and close friends. I don't think I'm really friends with any lawyers on Facebook. If I am, maybe they practice in other divisions or something. I just generally, I wouldn't accept or interact with any lawyers who would practice in front of me. Generally, just because, I don't know, just in case, I don't know. It's just, I just wouldn't, just doesn't seem, I wouldn't take the risk to do that. So I don't know if I'm really the best example, and I'm not very active on social media anymore, except to maybe post. If I do something with my kids, I'll put it up for my family to see. It is a curious thing, though. I mean, I guess that means still people can find me, but there's nothing that they're going to find that's revealing in any way. It's nothing exciting.
Well, being cautious is definitely the safer approach on that front.
I did when I was in dependency, like 6 or 7 years ago, I did have a mom. We had to terminate parental rights for a child. And that mom somehow found me and reached out to my daughter through me and sent her a message to tell your mom to give you my kid back. So I guess there is, Chris, you're right about that, potential safety risk.
Yeah. And I will tell you, I mean, currently I have an issue where my brother-in-law is getting emails every single day from a litigant that, because I don't have any sort of social media presence, went out and found the next best thing, which was to harass my family. And he literally gets an email every single day from this person. So I think as judges, that's always in the background is, how can we protect our family? And I think the safest way to do that is for us not to be involved in social media. I understand as lawyers, it's a different avenue and it's necessary for lawyers today. I mean, to get clients to be out there and have a presence, it's definitely necessary. But judges are in a different boat. I mean, and even one of the questions, I was appointed by the governor in the application process, and the whole vetting process goes through whatever your social media is. And they want to know what you've posted, where you've posted it. So for me, it was easy because I didn't have a lot of that to start with. But I know some people, that's a very hard part of that process, going through all that. So it's just something you need to be cautious about.
I mean, from the practitioner side, I will say there's some awkwardness if I have I'm not going to say names, but friends who are circuit court judges that are still on Facebook that haven't unfriended me because they've said we would disqualify ourselves anyway if you happen to appear. So we know how Facebook works. I mean, we have Facebook friends that aren't really friends; they're just there, but it's still nice to see their vacation pictures. But there's some awkwardness when your opposing counsel is, favorably commenting on everything that the judge that has your case is posting on social media. So that gets a little squishy. And overall, from the vantage point of a lawyer representing litigants, probably better not to have the judges interacting with counsel and opposing counsel via social media. Although I understand, you do want to have those, you do want a platform to be able to post the vacation pictures, which to me is the best and highest use of social media. I don't use it for like client development or brand development.
Well, it's really interesting to hear that we all have such different perspectives on it. And so I know our time is coming to an end in a few minutes. I wanted to touch on our final topic for today, which is equally as important, electronic data and records management. This is about more than just keeping your files in order. It's about protecting client confidentiality, complying with your ethical obligations, and building systems that support your practice, especially if you're working remotely or in a solo or small firm setting. It is important for all of us to maintain good cyber hygiene. That includes habits like avoiding public Wi-Fi, using complex passwords that are changed regularly, and understanding where our data lives and how it is being stored. The rules of professional conduct make clear that providing our clients with adequate representation may require the retention of technology experts. In addition, we are responsible for maintaining our clients' confidential information. Not understanding the technology is simply not an excuse. Not all of us are technologically savvy, but fortunately, the Florida Bar's Practice Resource Institute regularly publishes material and provides educational programs on information security. You can find those resources and many others on the Florida Bar's website. I think a lot of attorneys don't realize how many great resources are on the Florida Bar's website. Everything from data management to trust accounting to lawyer advertising guidelines. There's really a lot of great resources out there. So for our audience, make sure that you're checking it out. Arti and Paul, what tools or protocols do you use in your practice to protect client data?
Well, I can jump in just for a bit. And you're right, Jaclyn. The Florida Bar's best practices guidelines on cloud computing are really useful. And we can't outsource the obligation to maintain client confidentiality to vendors, right? Lawyers have an independent obligation to ensure that their client information is maintained as confidential. I sort of bridged the gap. I remember when our IT person was saying, "Oh, you got to delete your emails because you have too many emails." Those days are gone, right? Data is cheap. Lawyers use cloud storage, and everything gets preserved forever, right? We're in the era of big data, but that doesn't obviate the responsibility to ensure that your client data, if it's cloud computing, that means it's on somebody else's server somewhere, is protected. And the Florida Bar's outlines on this topic are fantastic, but include ensuring that your IT vendor, that they're compliant with the current best practices for confidentiality, that they agree in writing that if there's any breach that you'll be promptly notified, that they agree in writing, and I'm thinking about your IT vendors that are using cloud computing capabilities, if there's any subpoena, a request for public information that would impact client confidentiality data, that you are immediately notified and have an opportunity to object on your client's behalf. So we can't turn a blind eye to this obligation. There's a role for lawyers to play in interacting with their IT folks to make sure they're aware of and compliant with the obligation to maintain confidentiality. And that's how we do it. I mean, we use a professional IT firm, and we have them check the boxes that the bar requires to make sure the information stored on the cloud that's confidential to clients is maintained as confidential.
I'll add, just like he said, big data, opening your Wi-Fi, opening your email in any place that they can capture your information, you just don't do, right? You use a VPN. If you don't want to use a VPN, just work offline. That's honestly some of the best advice. Even when you log on to the airline, there's people who can capture your data. If you log into a Starbucks and you're not using a VPN, the VPN makes it awfully slow. Work offline. Work from the Word document, download it to your computer, and then work off and then put it back on.
We are coming to the end of our panel. I wanted to ask each of our panelists to give the audience a closing piece of advice about technology.
I'll start. For the young lawyers and the law students, I would say don't be afraid to ask questions when it comes to technology and electronic communications. Often students and young lawyers sometimes don't want to ask questions or admit that they maybe don't know the answer to something, but there are people who want to help you and want you to succeed. So don't hesitate to reach out and ask people questions when you have issues that come up related to technology.
And I guess I'll jump in. I think of AI is transformative in my mind, but I think of technology generally and changes in technology as like a wave. And you're either going to get on the wave or you're going to get tumbled by it, and then you're going to see it pass you by and you can't ride it again. So with AI in particular, there's just so much opportunity to be able to provide services more efficiently that I would just urge people to really figure out how to harness the power that AI brings in a way that's responsible, protects client confidences, but really makes your work for your clients more efficient.
I'll add, just be careful. Right? We need it, but it's like anything we do in practice. Just don't be afraid of it, but we need it, and just be careful in everything we do.
And I think from the judicial standpoint, the big thing is don't forget your common sense. So if you're doing something that doesn't seem right, it's probably not right. If it's as simple as showing up to a court hearing while you're driving in your car. I mean, if you use common sense when you're interacting with the court using digital technology, you'll be okay.
I think that it's another opportunity to make an excellent impression. It can also be a pitfall. So my only suggestion would be to just be present, be fully present when you're using technology as if you would be if you were communicating in person or on the telephone with someone, and make sure you put your best foot forward and take advantage of it as a platform to make a good impression.
Well, thank you all so much for sharing your knowledge and wisdom here today. It looks like we're on time. So with that, we'll close out today's panel.
Jaclyn, thank you so much for being such a great organizer and moderator.
Yes, thank you, Jaclyn.
It's a lot of work. You did a nice job.
Fantastic.
Thank you all. Have a great day. And I hope everybody has a great weekend as well.